Welcome, hello, my name is Geneva Perry and I'm the founder of Promise Law. If you're watching this today and you've had a death of a loved one, please accept our sincerest condolences. We're very sorry for your loss and hope that this presentation will give you guidance on the road ahead. If you've not lost someone, this is still an excellent primer on the issues to avoid. Whatever brings you here, you're coming into our world today and what we've seen when families try to go it on their own in probate. The presentation today will include learning a little bit more about Promise Law, and then we'll learn some basic terminology to make sure we're all on the same page. Then we'll dive into the 3 biggest mistakes in probate. Thereafter, we'll look at the takeaways. What do these mistakes tell us about the probate process? And then we'll review and close. We say life happens, plan on it. And so the planning includes being informed, intentional, and comprehensive in the probate process. We know it's overwhelming and sometimes scary to figure out what to do, but we promise to demystify the process, explain all the terms, and make sure that you know your options and obligations in the road ahead. Let's begin with the basic terminology. A decedent is a person who has died. The word testate refers to an estate where the decedent died with a will. The words testator and testatrix simply refers to the man or woman who created the will. Similarly, an executor and executrix refers to a man or woman nominated to administer the estate. An important point here is that they are nominated. They don't have automatic authority to act. An intestate estate refers to a decedent who died without a will. An administrator is the word we use when a decedent died without a will and the person is managing the estate. Personal representative is the gender-neutral term that's more frequently used to refer to the administrator of the decedent's estate. More terminology. Beneficiaries. Now that's one you might have heard before. In the world of probate, this means a person named in the decedent's will to receive the probate estate. Heirs at law. Now that's a word that sometimes gets confused with beneficiaries. The heirs at law are the people who under Virginia statute are entitled to receive the estate when the decedent died without a will. And remember, when they die without a will, it's called intestate. Qualification is the process of being formally appointed by the court and given authority to administer the estate. So a person can be nominated in a will, but the qualification process is what gives them the actual authority to administer the estate. Insolvent estates. We're going to hear a lot about those today. An insolvent estate is where there's more bills than money. This is a topic that will come up frequently in our discussion today. And lastly, the Commissioner of Accounts. The Commissioner of Accounts is the court-appointed office that oversees the probate administration process. They receive all the filings of the personal representatives and audit them. Now to mistake number 1, moving too fast in the process. Moving too fast on a decedent's estate happens where you qualify too soon. And the reason why it's a problem is it might not be necessary. As you'll learn later in the presentation, sometimes probate is not needed at all to transfer the decedent's assets. The second reason that qualifying on the decedent's estate is sometimes a bad idea is that there can be thorny issues like insolvency. And although it doesn't make sense sometimes, you just have to walk away from difficult estates. And lastly, there's the cost. Probate administration costs money. And if there's a way to transfer the assets without needing probate, then it's better to do so. Lastly, for the person who is appointed, qualifying on the estate is a big responsibility. The administrator who's appointed agrees to take on the duty of identifying all the assets, paying all the final expenses, and then distributing assets to the beneficiaries or the heirs. And if they do anything wrong along the way, they can be personally liable for errors, even if they didn't know and it was unintentional. So how will you know when you need to qualify on an estate? The answer is you need to see if there are probate assets in the estate. And not all assets go through probate. Property that is owned joint with right of survivorship does not go through probate. If the decedent owned property with another person or persons, and that was titled as joint with right of survivorship, it automatically goes to the survivors at the decedent's death. Beneficiary designated assets also don't go through probate. Those are accounts like IRAs or life insurance. In those instances, those funds are paid directly to whoever the decedent named to be the beneficiary, again, bypassing probate altogether. Then there are pay-on-death accounts or transfer-on-death accounts. Pay-on-death accounts are frequently seen with bank accounts. In that instance, the bank will cash out the account and give the funds to the pay-on-death beneficiary. Transfer-on-death accounts typically refers to brokerage or stock accounts. In those instances, those assets are transferred to whoever the decedent named as a beneficiary, again, bypassing probate. So if there are accounts that are joint with right of survivorship, pay-on-death designation, transfer-on-death, or beneficiary designated, they don't go through probate. So you might ask, well, what the heck is included in probate? It's only the decedent's stuff that is in their name alone, not held joint with right of survivorship, no beneficiary designation, no pay-on-death designation, and no transfer-on-death designation. It is anything that is just in their name alone, and it can include lots of stuff. We say stuff and not assets because everybody thinks assets are for the rich and famous, but everybody has stuff. Tangible personal property, bank accounts, checking accounts, real estate. But since we're talking about real estate, we need to spend a beat more on it. Real estate is special. We like to say it drops like a rock to the beneficiaries or heirs of the decedent. When a person dies and owns real estate only in their name, the beneficiaries under their will or their heirs, if they died intestate, receive the property once the will is recorded or the list of heirs is recorded. This has an important point with regard to probate administration because the beneficiaries or heirs are responsible for the real estate expenses. An executor cannot use probate funds to maintain the real estate. And even if a will gives the power of sale to a personal representative, they have no authority to sell the property absent court order or agreement of the beneficiaries. The only way the real estate can be sold by the administrator is by order of court or agreement of the beneficiaries, or unless specifically directed to do so in the will. Another way that executors move too fast in the process is to pay bills right away. And that seems like what you should do, right? You've got a bill, you've got the funds, you should pay it. Well, sometimes that's not the right thing to do for a couple of reasons. If an estate is insolvent, remember where there's more bills than money, the administrator can't pay whoever they want. There's a strict set of rules about who gets paid, how much, and in what order. And the personal representative can be held personally liable if they pay creditors in the wrong order, even if they didn't know the estate was insolvent when they made the payment. Executors sometimes move too fast with distributions to beneficiaries too. There are two ways this becomes a problem. One, you guessed it, an insolvent estate. Let's say an executor has distributed funds to beneficiaries and later finds there's more bills than there is cash. Do you think the beneficiary is going to be happy to give back those funds? What we've seen is that those funds are often committed to other expenses of the beneficiary and the executor is on the hook. A second way this becomes a problem is if there are disgruntled beneficiaries who aren't entirely happy with the process. Giving distributions to those beneficiaries too quickly gives them a war chest to then stir up trouble for the executor, either trying to have them removed or otherwise contest the probate process. Since we're on the topic of family, the second big mistake in probate is treating family like family, being too informal, and this is a business. Remember that probate is a court-supervised process. The court, through the Commissioner of Accounts, is going to audit all of the transactions taken by the personal representative. The filings, including an inventory and accountings, are going to be audited by the commissioner, and it's not like keeping a checkbook. If you're familiar with the rules of accountancy, it's more like a debit and credit system, and many very smart people have screwed this up. More importantly, failure to meet deadlines of the commissioner or to accurately file accountings can lead to the executor being personally liable or even removed from the estate. Where family is concerned, oral understandings can become misunderstandings. This by no means is an exhaustive list, but this is where we've seen executors run into trouble. The first is with regard to real estate. Remember, you can't use probate funds to maintain the real estate. We've seen where families have agreed, yes, sure, pay this bill regarding the real estate, make this repair and improvement, yes, that's fine, and then these beneficiaries don't agree later. The result is that the executor has to return funds to the estate, or if they're also a beneficiary, their share is reduced. Another large expense that leads to calamity are the burial expenses. At the time of the decedent's death, the family usually has unanimous agreement, yes, yes, we'll reimburse you, you'll get those funds back. But we've seen instances, though, where people later disagree about how much someone contributed, if at all. And then, can you guess what else happens? Insolvency. In an insolvent estate, there are limits to what the executor can reimburse. And we've seen instances where families agreed to reimburse another family member, but simply can't do so because of the rules of insolvency. And lastly, there are understandings typically about tangible property, things that Mama wanted. Now, she didn't put it in her will, but we know this is what she wanted. And sometimes families start out agreeing, yes, the crystal goes to Susie so-and-so, or the car goes to Harold whoever. But if they don't agree later, the executor is in hot water to explain these distributions to the court. The next way that probate needs to be treated like a business is with regard to taxes. The administrator is required to ensure that the decedent filed their last year's taxes. And many probate attorneys argue they really need to research the past 7 years to ensure that they are compliant with all of their requirements with the IRS. Another tax issue that arises is that estates can actually earn income. If the decedent had a brokerage account that was generating income and dividends, at their death, all of those income receipts and dividends are allocated to the estate. And it takes only a few $100s, and that triggers the requirement to file the 1041, which is the name of the return for taxes for an estate. And overlooking that can also get the executor in deep trouble. The third big mistake in probate is moving too slow. The first way this comes up is with spousal and minor child claims. When a decedent dies and leaves a surviving spouse or minor children, there are statutory claims that can be taken by them. These are claims of right. The spouse and children don't need to do anything to get them except to file on time. And if they've waited too late, they are lost forever. These are especially important claims in an insolvent estate because the claims of the spouse and minor children take precedence over all other creditors of the estate. Another aspect to moving too slow is with regard to beneficiaries. Some beneficiaries might be incapacitated or minors who can't manage their own funds, and sometimes there are special needs beneficiaries who might even be receiving government benefits based on their assets. So distributions to them can be especially problematic. It typically requires a petition to the court to resolve this if it's not laid out in the decedent's will. Moving too slow also means taking too long to identify and manage red flags. Again, this is not an exhaustive list, but a couple of biggies that we see. The first is where an IRA does not have a beneficiary. The rules in that case say that the retirement account has to be paid to the estate within 5 years of the decedent's death. Now that's a lot of income coming to the estate. and estates are taxed at the highest income bracket. So if an executor waits too long to handle this asset, they can have lots of income coming in and nowhere to distribute it out to. Another issue are assets with fluctuating value. If an executor has direction to sell the real estate, imagine what happens if a tree falls on the house. What happens to the value then? How happy will the beneficiaries be with them moving slowly for sale? Stock accounts are another example. What if the stock market plunges all of a sudden? Waiting too long to liquidate or transfer those stocks can lead to disgruntled beneficiaries who see how they lost value in that slow-moving estate. Moving too slow is really about seeing storm clouds and ignoring them, putting your head in the sand and not tending to the things that need care. And doing so, in our experience, results in a gradual decline to disorder. And it's only harder to get things back to right from there. So what are the takeaways from these 3 big mistakes in probate? The first is you don't know what you don't know. Some of the rules that we went over today are not what most people would guess. Sure, you can pay bills, maybe. Yes, you can make distributions, okay, but only if. There are lots of details that need to be covered before you take some action, and you don't know what you don't know. Timing is everything. Moving too quickly or too slowly can cause detriment to the beneficiaries of the estate and personal liability to the executor. And you can't unring a bell. Some decisions and transactions can't be undone, and it's important to have information in advance before you act. And a few more takeaways. What you may or must do depends on the facts and circumstances of the case. You can't know from watching this informational video what to do in your case. And this is not legal advice. And there's a better option anyway. Call Promise Law for a free 30-minute consultation about your situation, whether you've already been appointed as the administrator or you're just wondering if you need to get appointed. We can help you understand the issues and options and find the road ahead. And if you do need help, there's no obligation to hire Promise Law to do so. We want to help. Please let us. So let's review. You've learned the terminology of probate. You understand that someone who died with a will is testate, and intestate estates refer to people who died without a will. You know that a big important factor in this process is qualification. Qualifying on a decedent's estate is a no-take-back decision. You also know that the Commissioner of Accounts is the office that oversees this process. You've learned the 3 biggest mistakes: moving too fast, being too informal, treating family like family, and moving too slow. And you've learned the takeaways, that putting your head in the sand doesn't help, you can't unring some bells, and you don't know what you don't know. You've also learned that the next step is to call Promise Law. We're here to help, and we'd like to help. Remember, life happens, plan on it, but you don't need to go it alone. Thank you so much for your time today. I hope this has been a help.